Welcome back. Now, it doesn't seem like the political crisis in Rivers State will end anytime soon after an interlocutory injunction issued by the State High Court in Port Harcourt, which has now restrained the Martin Amaewhule-led House of Assembly from holding legislative activities pending the hearing and determination of the substantive suit. Now, this follows a similar ex parte order on May the 10th this year. Now, in the latest ruling delivered on Wednesday, May the 29th, the presiding judge, Justice Charles Wale, issued the following order. Now, this is the order. I read it. An order of interlocutory injunction is granted restraining the 1st to the 25th defendants from parading and holding out themselves as members of the Rivers State House of Assembly and or seating at the auditorium of the House of Assembly quarters located at Aba Road, Port Harcourt, or at any other place whatsoever to purport to carry out the legislative business of the Rivers State House of Assembly, their legislative seats haven't been declared vacant pending the hearing and determination of the substantive suit. An order now of interlocutory injunction is hereby made restraining the 26th to 28th defendants from dealing with, interfacing, accepting any resolutions, bills, or howsoever interacting with the 1st to 25th defendants now in their purported capacities as members of the Rivers State House of Assembly. Their legislative seats haven't been declared vacant with effect from 13th December 2023, pending the hearing and determination of the substantive suit. Now, that is, and then the case, of course, that's the interlocutory injunction. Now, the case, of course, has now been adjourned to 1st of July 2024 for mention. Let's now discuss the legal implication of this latest development. Joining me on the show now is Justice Ojieno, who is a legal practitioner. Justice, thank you very much for coming on the show. Help us to understand and interpret this interlocutory injunction. What exactly does it mean?
Okay, interlocutory injunction usually is an injunction that has to be filed before anybody can even apply for an ex parte interim injunction. An interlocutory injunction is the injunction that sustains status quo pending when the court finally hears or conducts the trial in full and comes to a landing conclusion on a particular issue. So it is so that while the matter is going on in the High Court, whether it's for 6 months, it's for 1 year, it's for 2 years, or however long, that parties should maintain what is contained in the order or injunction of the court. So that's essentially the essence of the interlocutory injunction. At the end of the day, the court can change its mind. The fact that any party has been victorious at the interim stage or at the interlocutory stage doesn't mean that at the what we call perpetual stage, which is the end stage, the decision will be the same. So all parties are supposed to still keep their gunpowder dry largely.
Now we know this. Okay, so does this, because when you hear the part of the interlocutory injunction now saying that their seats, the seats of these lawmakers, haven't been declared vacant, so does it mean in this case the judge recognizes or is recognizing that the seats of these 25 lawmakers have been declared vacant when that has not been well proven, if you like, and is still a subject of contention in another court?
Okay, we must also understand that the nature of the interlocutory injunction is not that the court has decided.
Yes.
Because essentially the court has not looked at and has not come to a conclusion as to the weight or quality of evidence. So interlocutory too doesn't say that, okay, this is where the court is landing. And that was why I said that at the end of the day, what we should wait for is a perpetual injunction stage. Because, of course, that will also constitute some of the prayers that the claimants or the petitioners in this case will be asking for. So the fact that there is interlocutory is not simply an endorsement of a particular line of thinking by the court. We still have to wait for the court to assess evidence assess arguments, and land on one side or the other. So interlocutory still is, yeah, maybe a temporary victory, but is not an endorsement by the court, because the court has not had the opportunity to fully evaluate what is before it before coming to a fair conclusion.
Now, the reason why I asked you that question is because of the language of the interlocutory injunction itself. At some point, the judge said in the interlocutory injunction now that their seats haven't been declared vacant. Does it mean the judge is now saying that the seats of this 25 lawmakers have been declared vacant? Because we also know that that is also a subject of it's a subject of litigation in another court. I'm looking at the language now. I'm looking at the language used in this interlocutory injunction, because there's a reason why when the news was reported by all the major media houses, it was reported that the court, that the judge had said that that the seats of the 25s have been declared vacant and that they are no longer lawmakers in the eyes of the law.
Okay, the situation of things with respect to that is, yes, mathematically, pending when the court changes its mind or when the court gives the perpetual injunction. So the period in between this interlocutory injunction now and the perpetual injunction, between those periods, yes, their seats are vacant. But of course, we also know that there are still options open to these lawmakers. They can appeal the ruling or order of the court with respect to this. And even before the perpetual comes, or before the court decides before the High Court decides finally, there can be an intervention by a higher court, giving maybe striking down this ruling or order of the High Court. So pending when any of these two things happen, the position of the law, the implication of this judgment is that pending in between those times, the seats are vacant. The judgment of the court subsists. The seats are vacant. Whoever it is that is the speaker that is sought to be prevented by this suit can no longer parade himself as the speaker, and the other persons too cannot parade themselves as members of the House. So that basically is the implication of this judgment until there is an intervention or until there is a contrary intervention, either by the High Court itself or by a higher court. It can be the Court of Appeal, and even after the Court of Appeal, it's still open for the defendants to still say they want to go up higher to the apex court of the land. And if they get the intervention from the apex court of the land, then whatever it is that the legitimate courts decide becomes what will pervade and what will carry the day.
We know that this case is before some other courts as well. In fact, it's even before a federal high court, I think in Abuja. And all these courts have made pronouncements. So as it stands now, which court order should be obeyed? Because about 3 or 4 courts now have, are actually litigating on this case, and they've issued different kinds of orders and what have you. So in this situation, which court order now would prevail?
Okay, for me, Mr. DEJI, that's a very, very difficult question. Usually, all court orders must be obeyed. I know that the legitimacy of your question is also probably drawing from what is presently happening in Kano State, where we are having a very, very unfortunate situation of one court overriding another court, and litigants having to pick and choose which side of legitimacy they want to say they are drawing their right to take particular actions or take particular stands from. For me, I think it is very, very largely unfortunate, and it puts every lawyer in a very, very difficult situation, especially because the courts are courts of what we call coordinate jurisdiction. their powers are not more than the powers of, for example, the Federal High Court is not higher than the State High Court. So if there are conflicting decisions of courts of coordinate jurisdictions, I feel that it is very, very largely unfortunate. But usually, if it's the contradicting decisions of the Supreme Court, we usually say that the Supreme Court decision, which is latest in time, is what should be followed. But as a practitioner, I do not think that can be used in this situation. We cannot say that the High Court, which is the latest in time, is what should be followed. So I feel that it is a conundrum that any lawyer practicing will find hard to either say a yes or no to, because all court orders must be obeyed. And this again is a clarion call for the members of the judiciary, especially the members of the NJC, to call the judiciary to order, respect when it comes to issuing of ex parte orders or contradicting decisions of courts. I know that generally a judge is supposed to decide a case based on the facts that are placed before it and not based on extraneous factors. But we may have to vary that or measure that a bit, because if we decide to stricto sensu abide by those principles of law, we may have a situation where the country practically, God forbid, burns down. So I advise that as much as possible, the persons in charge of running the judiciary, the NJC, the Federal Judicial Service Commission, and every other principal stakeholder in the judiciary should ensure that we don't even as lawyers find ourselves in a situation where we are picking and choosing out of the various valid orders of court and cherry picking which that our clients should obey and which our clients should disobey, because disobeying of a court order is something that is strongly against the rule of law and an anathema that should never ever be encouraged.
Justice, just before I let you go, I have one final question for you. Would it be out of order to say that the Rivers State judiciary has become partisan in this matter, especially in this political crisis involving the State House of Assembly, the governor, and of course, the governor's estranged political godfather, Nyesom Wike? Could we say, would it be out of order to say that the Rivers State judiciary appears to have become partisan in this matter?
Okay, for me, I also think this is also going to be a very, very difficult one for me to answer, because usually, in a manner of speaking, there is really not that much Rivers State judiciary, because the discipline, promotion, appointment of members, principal members of their judiciary are still done centrally at the national stage. So that's why usually we complain that our federalism is not deep enough, because there are still some situations where they are central. So I may not want to go ahead and cast a strong direct aspersion.
I can understand. I can understand if you don't want to do that. I really can understand. But go ahead.
But for me, as much as possible, and as has been said, especially also in our constitution, and if you also go to check, especially the abundantly wise decision and advice from late sage of a jurist, Nikki Toby, in Buhari and INEC, where he said that as much as possible, members of the judiciary should not commingle with members of politics, because the judicial business by itself is a business that deals principally in not being biased, whereas politics by its very, very nature is built upon being biased. That if we have a situation where there is too much commingling between the judiciary and the politicians, there is going to be chaos in the society. So I think that as much as possible, members of the judiciary should always be reminded, they should keep going back to that case to draw wisdom, and wisdom from strong justices like Justice Sowemimo of blessed memory, Justice Ogundare, Justice Elias, and the great wisdom that they have enumerated in cases in this country. So that as much as possible, even if they are not biased, people do not have to see them as biased, because to an extent, the mingling, the commingling, the engendering of politics in the judiciary and the interest of politicians in judicial decisions is way becoming too much. And again, we should all be careful, because at the end of the day, the currency of the judiciary will always be confidence. The moment the people lose confidence in the judiciary, then the judiciary has lost its essence. And if there is no judiciary in a country, it's either it's a dictatorship or we go back to the Obesian state of nature, where everything actually just degenerates and becomes oblivion.
Well, Justice Ojeno, thank you very much for talking to us, and thank you for your explanations there.
It's my pleasure.
Thank you so much. We'll take a short break and we'll be right back. And this time, we'll be talking tax matters. Stay with us, don't go away. Opinions are free, facts are sacred, but truth is universal. How, in practical terms, can we, for instance, de-escalate the tension?
Because when you go into public office, you must be ready to answer to the people.
We know where the enemy is. 3 places. The Lake Chad Basin, the border area between Nigeria and Cameroon, and then the Sambisa Forest.
On DEJI360, we give you a complete dose of everything. Opinion, facts, and undiluted truth.
I hardly believe what politicians say in this part of the world.
A new Nigeria is possible, a future is possible.
We delve into the issues, dissect it so that you can understand it, use it to take action.
I don't think there's any need for any governor to look for grant for ranching.
DEJI360, dissecting the issues.